So, hi everyone, this is a continuation of our discussion of certainty of intention. And here I look at the phenomenon of precatory words. So this is a typical scenario where someone has used uncertain words that imply a moral duty rather than a legal duty. So, certainty of intention requires you to impose a legal duty on the trustee, not a moral one. Because remember, when we create a trust, part and parcel of that is that we put strong duties, we call fiduciary duties, onto the trustees. So these are some fictional examples, and I'll look at the two main leading cases in the following slides, but now just look at typical examples of the kinds of words and phrasing that could make you think, these could be moral duties, precatory words, rather than legal duties, and so a trust. First one is, I leave my estate to my husband on the assumption he looks after our children from the proceeds. So it's the phrase on the assumption. Now, is that imposing a legal duty or is that imposing a moral duty? Again, we could come back to the point that, had they gone to a lawyer, they wouldn't have said stuff like that. We're not dealing with that situation because in the real world is much more complex, and people do sometimes, including sophisticated business people and otherwise very able people, write things that they think amount to a legal duty or amount to a moral duty, and we have to figure out from all the circumstances as well as that particular document what it means. It's not obvious what on the assumption is a legal duty or a moral duty, and I think you can make a good case for either. And I think that's how you would answer that type of question in an exam. Any kind of ambiguity, you always argue, well, you always explain why it's ambiguous, and you give the implications. Well, if it's a legal duty, then it is a trust, and therefore we've appointed the husband as a trustee and the children as beneficiaries. On the contrary, if it's not a legal duty and just a moral duty, then obviously we haven't created a trust. What we've created is a gift to the husband. That's it. And that's the implication of it being a moral duty. It's just a gift. So we look at all the facts around it. We look at who that person was, what they had in mind, the relationship between the husband and the kids, etc., etc. Another example is the second one there, fictional example. I leave my estate to my aunt in the hope she uses it to look after her children. Again, that is more than the first example, a moral duty, I think, because in the hope is not strong enough without, other context, without knowing the full context. It's difficult to know, but just everything else being equal, just that use of the words implies it's a moral duty and therefore is a gift to the aunt. So let's look at the leading cases now. Word of warning, these are quite old cases, and therefore I think, as we'll discover when we talk about the critique of the certainty of intention, I think it would be someone quite brave that thinks a court will decide these cases exactly the same way as they were in the 1800s and the early 1900s, not least because they make certain assumptions about the family structure and responsibility and so on. So just a health warning that, I suppose technically this is the law, but whether or not a modern court would look at these things in the same way, I'm not so sure. So the first is Adams and Kensington Vestry, and here the testator left an estate to his wife, saying in full confidence that she will do what is right by her children. So the husband, in his will, left his estate to his wife in full confidence she will do what is right by her children. Now, is that just a legal duty, or is that just a moral duty? If it's a legal duty, it's a trust and the children are beneficiaries and the wife is a trustee. If it's not, then it's a gift. Court held it's a gift because in full confidence means that we don't need to imply fiduciary duties between a wife and children. The intention was, and this is back in the 1880s, that in the absence of a husband, the wife becomes head of the family. Okay, now as I say there, that this was a 1884 case, so therefore it's a very kind of patriarchal, antiquated view of the world. Is it necessarily the case that a mother would always have the best interests of her children at heart? Right? That's possibly right, 9 out of 10 times, but it's not necessarily the case that that's always going to be correct. The other case is Comiskey. Again, very old case. The will was contradictory. At some points it says, I leave my estate to my wife absolutely, in which case it's simply a gift to the wife, and in other places it says that to the wife and then to the nieces, which implies that there is a gift, that there is a trust for the wife and the nieces, the wife being the trustee and the beneficiary, and the nieces being beneficiaries. So the court listened to witnesses, read the will in context, and in particular it looked like there was very clear intention that some benefit would go to the nieces. So they found that this was a trust. Two reasons that the court came up with, and commentators have come up with a third to explain it. Firstly, the court said that the property that was going to go to the nieces wasn't clearly separated from the property that would go to the wife, implying that the wife takes everything as a trustee but shares the position as a beneficiary. And that's slightly odd because, as we'll see, certainty of subject matter requires separation. But because the wife and the nieces would be beneficiaries, maybe that wasn't so important. Secondly, and as I've already said, whatever the will said, no matter how contradictory some of its provisions were, there was an intention to benefit the nieces. But you could say that about Kensington Vestry. That's why some commentators, for example Professor Hudson, see the differences here as really the identity of the beneficiaries. These were nieces, whereas in the previous case of Readams, Kensington Vestry, they were children. So it doesn't follow that that the kind of same assumptions one would have about a mother doing the best for her children would be translated into a situation between the nieces of the testator. And that's why they say, those commentators say, that a legal obligation was read into Comiskey. And that is quite a sort of convincing point of distinction. I'm not saying it's a good one, but it's a convincing one to explain the different outcomes. So, moral of the story is, when you have words that are like hope on the assumption that I give so-and-so this property because I reckon they will look after it. If you're going to use slang, the court is going to look again at all the circumstances, but it's going to have a very close eye on those words, because all else being equal, their use implies a moral obligation, meaning this is just a gift, as opposed to a legal one, which would create a trust because you're imposing fiduciary duties implicitly. In the final podcast, next podcast on certainty of intention, I look at the issue of separating out property as indicating a certainty of intention. All will be clear in the next podcast. Hope that has been useful, and I look forward to seeing you then.